Hi, my name is Kelly Acosta, and this week I will be talking about competence to be executed and to participate in and waive appeals, Module 3. I wanted to first look into the history of competency and how we got to where we are currently at. So the Supreme Court's 1986 ruling in Ford v. Wainwright held that the Eighth Amendment, which bans cruel and unusual punishment, prohibits the execution of an insane person. Courts did not have a definition of competence at the time of the ruling in Ford v. Wainwright, but the court held in Ford v. Wainwright that the Eighth Amendment prohibits the state from carrying out the death penalty on an individual who has a severe mental illness, and that properly raised issues of the individual's mental health at the time of execution must be determined in a proceeding satisfying the minimum requirements of due process. The Ford Court noted that the execution of persons with severe mental illness had been considered cruel and unusual at common law and at the time of adoption of the Bill of Rights, and continued to be so viewed. And although no states purported to permit the execution of persons with severe mental illness, Florida and some others left the determination to the governor. Florida's procedures, the Ford Court held, violated due process because the decision was vested in the governor without the defendant having the opportunity to be heard. So the governor's decision being based on the reports of the 3 state-appointed psychiatrists in the case.
Can the death penalty be exacted on a mentally ill prisoner? Ford versus Wainwright takes up this question.
I felt like this little video really described Ford v. Wainwright accurately and quickly, so we're going to go ahead and watch this really quickly, and I'll attach it as well in the description box. So I wanted to take a little bit to talk about the American Bar Association and where they play their role in all of this. So the American Bar Association, or the ABA, has called for an exception from capital punishment of any individual who has a mental disorder or a disability that significantly impairs his or her capacity to understand the nature and purpose of the punishment or to appreciate the reason for its imposition. The ABA reasoned that an offender should not have a shallow understanding of why he or she is being executed, but rather an understanding of why society has decided to impose the ultimate punishment. The resolution that was put forth by the APA also provides that if the person who is incompetent in this sense is unrestorable, then the death sentence should be commuted based on the rationale of Jackson v. Indiana. And remember, in Jackson v. Indiana, Mr. Jackson was a deaf-mute man who could not read, write, or communicate. Indiana committed him to a state hospital before he was even able to be found guilty because he was deemed incompetent to stand trial based on that. So the ABA also proposes a decisional competence rule governing the person who has a mental disorder or disability that significantly impairs his or her capacity to make a rational decision to forego or terminate post-conviction proceedings available to challenge the validity of his conviction or sentence. So this leads us to competence to be executed at the time that the death warrant is signed. So the focus of this evaluation is to see the individual's cognitive functioning, whether that individual has a rational capacity to understand that he or she will be put to death and why they are being put to death. After the ruling in Panetti, an inquiry must also be made into why the defendant believes that society has sought and imposed he or she being put to death. In Panetti v. Quarterman, it was decided 2 decades after Ford, and they upheld what was found in the Ford case, but they also held that someone is incompetent if his awareness of the crime and punishment has little or no relation to the understanding of those concepts shared by the community as a whole. As of today, there are 2 professional judgment tools: Ebert's competency to be executed rating instrument and the interview checklist for evaluations of competency for execution. So the use of these tools is to ensure a comprehensive inquiry into relevant capacities. Each tool uses 3 domains relevant to execution competence: the inmate's awareness of punishment, which is the understanding that he or she will be executed; the awareness of why he or she is to suffer it, which is the understanding that the execution is occurring because of the crime for which the offender was convicted; and finally, the inmate's ability to assist their counsel. So both of those professional judgment tools include all 3 of those domains. So I wanted to discuss some ethical considerations. So there are some ethical sensitivities surrounding the examiner who is performing the evaluation that could lead to an inmate's execution. Remember, it is up to the mental health professional to ensure that they are capable of conducting a valid and objective assessment, ensuring that their beliefs don't get in the way of them being able to do that. So some people argue that mental health professionals should play more of a limited role in such types of evaluations. The American Psychological Association has actually weighed in on this, and they opposed the participation of psychologists in routine certification of competency for execution. In their view, the justification for participation in such evaluations should be based solely on the possibility of bringing new information which might change the legal verdict and subsequent death sentence. So one of the last things that I wanted to go ahead and talk about are treatment issues. When does treatment become unethical? The conflicting beliefs surrounding that. And when we're talking about treatment, we're often referring to treatment to restore competency. So, the National Medical Association has adopted the position that physicians should always provide treatment regardless of the inmate's legal situations. So both the NMA, which is the National Medical Association, and Richard Bonney agree clinicians are obligated to provide treatment even if it will lead to the prisoner's restoration of competence to be executed. Now, where it's conflicting is that Bonney believes treatment should be based on whether prisoners state that they want the treatment at the time that they are capable of making that decision. Contrary to the National Medical Association stance, Bonney believes that it is unethical to provide treatment if the inmate's desires are unclear, the inmate competently refuses treatment, or if the inmate is incompetent to make treatment decisions. Bonney states that the clinician would be serving a role that is ethically indistinguishable from that of the physician who administers the lethal injection of barbiturates. I just wanted to very quickly say thank you for listening, being patient, and dealing with how word-heavy This presentation was